you. Before we get started, I'm going to start with an apology. Carrie and I, unfortunately, are both lawyers, and like most lawyers, we're logophiles, meaning we love words. And so there's a lot of words in our presentation. And we kind of built the slides around the idea that they should stand alone as a resource document. As you heard, you'll receive them after the presentation. So as time gets tight, we may skim over some of the material. If we skim over something that is that you have questions about, or if we inadequately explain something, do take advantage of the Q&A options. We're again going to be covering restraint and seclusion in schools, in public schools. We're going to do this in a volleyball fashion. So I'll start off by covering some very brief background information. Carrie will take over key definitions. I'll take over prohibited actions. Carrie will cover the, when restraint and seclusion can be used. I'll cover the what notification and reporting requirements are contained in the regulations. And we'll do what provisions of the regulations address prevention, the training requirements, and the like. So what do we know right now about the use of restraint and seclusion in public schools? Unfortunately, the honest answer is not very much. What data is available is quite limited because there's been no state level requirement for reporting these data. As you'll see on the next slide, there is a requirement that incidents of restraint and seclusion or the frequency of their use be reported to the Office of Civil Rights. And on our next slide, you'll see that a majority of Virginia's districts frequently report 0 incidents. This is 2015-2016 data. 74 out of 132 divisions, including Fairfax County, reported 0 incidents. But we also know from investigative reporting that, in fact, there were more instances of restraint and seclusion in the county of Fairfax than were reported for the entire state of Virginia that year. We also know from what data is available that these things are are disproportionately used on students with disabilities. And so on our next slide, there's some important dates in mind. Restraint and seclusion's been regulated in private day schools for students with disabilities since at least 2004. But it wasn't until 2015 that the Virginia General Assembly passed a statute directing the Virginia State Board of Education to promulgate regulations on their use in public schools. And it was this month that those regulations, 6 years later, finally became effective. Our next slide, you'll see the statute passed by the General Assembly. I won't read it to you, but there's the important part there is that in addition to directing the promulgation of these regulations, the General Assembly said that those regulations have to be consistent with, among other things, the 15 principles published previously by the U.S. Department of Education, which include probably the most important one, that restraint and seclusion should only be used when they're necessary to prevent imminent physical harm to self or others. On our next slide, we're going to be providing throughout the rest of the presentation citations to the regulations as we go. For folks who are unfamiliar with how the Virginia Administrative Code is organized, this is really just a reference for you to look back to if as need be. These regulations are contained in Title 8 of the Virginia Administrative Code. 20 just refers to the Board of Education's portion of that title, and they're in Chapter 750. As I mentioned, restraint and seclusion have already been regulated in private schools for students with disabilities. We're not going to cover those today, but for reference for folks interested, you can find those in Title 8 as well, in Chapter 671, and predominantly in only 2 sections, Section 650 and 660 of those regulations. So I'm going to turn it over to my colleague, Carrie, to go over key definitions.
So we're going to be talking a lot today about when restraint and seclusion can and can't be used in accordance to these new regulations. But a really good place to start is, how do these regulations even define seclusion and restraint? So we're going to spend a few minutes now talking about what those definitions are. The new regulations break restraint down into 3 different types and provides definition for each. That's mechanical, physical, and pharmacological. So mechanical restraint is the use of any material, device, or equipment to restrict a student's freedom of movement. You'll notice here that under the definition, there is an exception for any device that's implemented by a trained school personnel that is being used in accordance with a prescription from an appropriate medical professional or other related medical professional, and with parental consent. So you'll notice here that mechanical restraint it's not considered mechanical restraint if you're using a device that is prescribed by an appropriate medical professional and is also being used within that parental consent. So that's really important to remember. Next, we've got a couple of pictures here of what some examples of mechanical restraint could be. The first is a picture of handcuffs. Under the definition in the regs, handcuffs would be considered a mechanical restraint. And then on the right over here, we have a device that's called a restraint chair. Generally, you don't see these being used in especially public schools. In our work, we do sometimes hear of instances across the country where they may be used in more residential settings. But basically, an emergency restraint chair is a chair that has straps maybe either around the waist or arms or legs that's used in order to secure an individual. Now, these are a couple of devices that are made to restrain a person, whether it is a student in a school setting or an adult. But under the definition of restraint, you'll remember I said any device. So that could be, a shoestring, a t-shirt, a blanket. If a device or material is being used to restrain a student under these regulations in this definition, it would fall under the definition of mechanical restraint. So the next type of restraint that's discussed in the regulations is physical restraint. Physical restraint is defined as a personal restriction that immobilizes or reduces the ability of a student to move freely. It does not include a few different things here. Briefly, holding a student to calm or comfort them. So for example, say there's a young student who's upset and the teacher goes over to give them a hug. That would not be considered physical restraint under this briefly holding exception. Holding a student's hand or arm to escort the student safely from one area to another. So if you think of, a kindergarten class walking down the hall, maybe to the art room, holding the student's hand to help guide the class down the hallway would not be considered physical restraint under the regulations. The use of incidental, minor, or reasonable physical contact or other actions designed to maintain order and control. So again, you want to look at the keywords here. We've got incidental, minor, reasonable. You'll see the word reasonable used a lot in these regulations, which is a way to allow it to be flexible enough to encompass a wide variety of scenarios. But there are some limited exceptions here for which physical contact may not be considered physical restraint under these regulations. The next type of restraint is pharmacological restraint. And this is the use of a drug or medication used on a student to control behavior or restrict freedom of movement. This does not include drugs or medication that are prescribed, again, by a physician or other qualified health professional that's under their authority to prescribe that, and as long as it is administered in the way that it is prescribed. So that would be the exception to something being considered a pharmacological restraint. Now we want to talk a little bit about seclusion and the definition of seclusion. So under the regulations, seclusion is an involuntary confinement of a student alone in a room or area from which the student is physically prevented from leaving. So some of the key words in this definition is, again, the student is alone and they're physically prevented from leaving. And then the regulations outline some specific activities that are not considered seclusion under this definition. The first being timeout, which we'll talk about in just a few slides. The next being in-school suspension, detention, student requested breaks, or removal of disruptive students from the classroom. And in addition, there is another carve out here under the definition of seclusion, and that is the confinement of a student alone in a room or area from which the student is physically prevented from leaving during an investigation for either a suspected violation of that student of the code of conduct, or that the student has knowledge of an event related to a violation of the code of conduct. So there's a few, again, exceptions here to that general definition of seclusion. So what does a seclusion room or seclusion area look like? Where can seclusion occur? We're going to take a few examples here to give you a little bit more of an example, practically speaking, of what this definition could entail. Now, I will say here, John's going to mention in a bit, there are some regulations related to what kind of areas can be used for seclusion under the regulations. So these pictures I'm showing you are not in accordance with the regulations for what a seclusion area could be. They're just simply areas in which seclusion under the definition of what seclusion is could occur, whether or not it's a permissible seclusion under the regulations. So the first one here is a very traditional seclusion room, a room that is designed for seclusion. There's padded walls, there's a door that can be closed, there's a small window to view an individual. This is something that a lot of people think of when they think of seclusion room. I think another picture that sometimes comes to mind is something that's more of a makeshift room, something that's an area that's built within a classroom, as you see here. But under the definition, you have to remember that in accordance with these regs, it's any area where a child's left alone and physically unable to leave. So it could be, for example, a therapy room or a staff office. A child could be secluded in a staff office. Or finally, looking here, it could be a room like this that has a lot of sensory supports, some sensory friendly seating, books, things like that. If a child is physically confined to an area, even an area that looks like this alone, that would be considered seclusion under the definition of the regulations. And so now we're going to talk a little bit about the definition of timeout. So the regulations define timeout as a behavioral intervention in which the student is temporarily removed from the learning activity, but in which the student is not confined. So you'll notice two key differences here between the definition of seclusion and timeout. The first is temporarily removed. So that implies that it's a relatively short time period that a child is in timeout, and the student is not confined. They're not physically prevented from leaving. So it's really important, you know, if you're working with a school or you're talking about these things, that you understand the difference between timeout and seclusion and make sure that what everybody is talking about is using the correct term for what that is in practice. So we've got a couple of quizzes here. We're not going to pull the group because we want to make sure we get through all the material today, but some examples of what could or could not be seclusion. So just hang on one second here while I grab these. So the first scenario, we've got a student who's sent to an area of the classroom called the thinking corner for throwing pencils at a classmate. The teacher instructs the student to think about the reasons why he can't throw pencils at other students, and he's not allowed to participate in the class's group activity while in the thinking corner. Now that, depending on the specifics for all of these, is likely not going to be considered seclusion, because if it's just the thinking corner, he's still within the classroom with his other students, with the teacher, he's not alone, so that would not be considered seclusion. Scenario 2, a student is sent to the reflection room for 2 hours by her teacher for disrupting class. Student is alone in the reflection room with the reflection room teacher and is assigned to write a passage about disruption in the classroom. So again, the student's not alone, they're with a staff member, so that's likely not going to be considered seclusion either. And then the third scenario, you have a teacher who places a student in her office, which is attached to the classroom, and locks the door while she waits for some additional staff to arrive. The teacher and student can see each other through a large interior window that connects the classroom with the office. They can talk to each other. There's the students there for maybe 2 minutes before some additional staff arrive and they talk to the student. Now under the regulations, assuming again, based on the facts, looking a little deeper into it, that would not meet, or that would meet the definition of seclusion, because that student is alone in that room, in that area, and they're physically unable to leave because the door is locked. So that's just a few different examples of what could and could not be seclusion under the definition that's in these new regulations.
Right. We're going to talk about some things that are explicitly prohibited by the regulations. And first, we have, on the next slide, mechanical and pharmacological restraints. You just heard the definition of those a moment ago. Also prohibited are prone restraints. Prone restraints are restraints in which an individual is restrained while lying face down. They present particular risks of suffocation. Those are prohibited. As are any restraint or seclusion that restrict a student's breathing or harm the student. Fairly straightforward on that slide. Additionally, the purpose for which restraint and seclusion is used is important. You cannot use seclusion and restraint consistent with regulations as a means of punishment or discipline. It kind of irks me that sometimes you hear about restraint and seclusion being discussed as a subcategory of the broader topic of discipline. Restraint and seclusion are not discipline, it's a separate subject. Restraint and seclusion is an emergency intervention that poses substantial risk of harm. It is not a teaching event. Restraint and seclusion may not be used as a means of coercion or retaliation. They may not be used as convenience. It may be convenient to place a child in a room from which they cannot leave, but that's not a reason to do so. And this is an important one. Restraint and seclusion may not be used solely to prevent property damage or in any other manner not allowed by regulations. That's kind of straightforward, but the property damage one is it's one that was somewhat contentious during the development of these regulations, and it's an important one. On our next slide, this is another important one, and that's why I included a little more verbiage on this one. And we're going to come back to this at the end of the presentation. Restraint and seclusion may not be used when medically or psychologically contraindicated, so long as that contraindication is documented by either an IEP team or a 504 team, by other school professionals, or by qualified and medical or mental health professionals. So when would that be the case? In a prior life, I worked as a mental health specialist in an acute care setting. I recall we had an individual who was admitted to our facility, in which restraint occurred on occasion, who had a metal rod inserted into his spine. For that individual, lots of types of restraint would be contraindicated because of the substantial risk of physical injury. Think of a child who's been the victim of abuse. If that abuse involved being locked in small spaces like a closet, it's not difficult to see how that could result in a psychological contraindication to the use of seclusion. We'll return to this again at the end, as I mentioned. Moving on to the next slide, also prohibited are any use of aversive stimuli. That's the use of anything that's intended to cause pain or discomfort. Use of corporal punishment, the use of seclusion rooms that don't meet regulatory standards. Those standards are somewhat, a couple of the standards are specific, but they're not that specific. I didn't include them in the slides, but they include things like you have to have adequate lighting, ventilation. If it's a room designed to be used for seclusion, there has to be a means of seeing inside the room. You can't lock a child in a closet where you can't see them to make sure that they're safe. You have to be able to put eyes on them at all times, things of that nature. And if you're interested in looking into those further, they're located on in section 50 of the regulations.
So John just went over some specific outline circumstances where restraint and seclusion are explicitly prohibited by the regulations. In addition to that, the regulations also talk about the ways in which restraint or the circumstances in which restraint and seclusion may be permissible. And absent those criteria being met, restraint and seclusion is not to be used. So we're going to talk about that now. This section of the regulations explicitly states in the beginning that nothing in this chapter shall be construed to require a school division to employ physical restraint or seclusion in schools. So at the beginning of this section of the regulations, it makes very clear that schools are not required to use restraint and seclusion. And in fact, if we have time to talk about it a little later on, John may expand upon, some school divisions are actually working on implementing policies to phase out or completely eliminate restraint or seclusion or both. So that's something that the regulations explicitly do allow schools to do. So before restraint and seclusion or seclusion can be used, school personnel are required to make sure that physical restraint or seclusion, they have to first reasonably determine that other interventions would be ineffective. And what's reasonable, the regulations outline that that is reasonable based on what a reasonable school personnel would do in an emergency situation. So the regulations contemplate that you may be employing restraint or seclusion in a situation that is arising, isn't planned out, but it has to be reasonable under those circumstances. So again, that determination is based on what's reasonable. It has to be reasonable. And this language also implies that restraint and seclusion should be a last resort, right? Restraint or seclusion can only be used when other interventions would be ineffective, or those other interventions have already been employed and they were shown to be ineffective. So the regulations then go out and outline particular circumstances that would permit school personnel to use restraint or seclusion. The first is preventing a student from inflicting serious physical harm or injury on yourself or others, quelling a disturbance or removing a student from the scene of a disturbance, but in which those disturbances or that student's behavior or damage to the property threatens serious physical harm or injury to persons. So it's not just to quell a disturbance, it's when the behavior or damage to property would threaten serious physical harm or injury to people. Defend yourself or others from serious physical harm or injury, obtain possession of a controlled substance or paraphernalia that's upon the person of the student, so as actually on that student's body, within the student's control. So that does not encompass, if there was a controlled substance in a backpack that's all the way across the room or down the hallway. And then 5, obtain possession of a weapon or other dangerous object that's upon the student or again within the student's control. So you'll notice a common theme here under these allowable uses is that it's all centered around physical harm or injury. And as John mentioned earlier, where property damage is mentioned, it's again tied to that physical harm, risk of physical harm or injury. So limitations regarding the use of restraint and seclusion. Physical restraint or seclusion has to be stopped as soon as there is no longer an imminent risk of harm. And generally when the word imminent is used in a regulation, that means right then, in the next few moments, there's a risk. Not 30 minutes from now, not an hour from now. So as soon as that imminent risk of harm has gone, physical restraint or seclusion must stop. School personnel are not required to attempt less restrictive interventions when they reasonably determine that these interventions would be ineffective. So again, if there's other less restrictive interventions that would be effective, those are supposed to be employed first before restraint or seclusion are used. Again, property damage itself does not justify the use of restraint and seclusion. It has to also create that imminent risk of physical harm or injury.
All right, I'm on again. So notification and reporting requirements. This is an important section of these regulations. As I mentioned at the beginning, the data we have right now is limited and inaccurate, and that's largely because of a lack of structure for the documentation and reporting of restraint and seclusion incidents. We've also We know from roots that there have been instances of restraint and seclusion that occurred for which parents knew nothing about until sometime in the future. And there probably have been instances that parents never learned about. And so these things are really, really important. The requirements in these regulations are that when a restraint or seclusion occurs, the school has to make, quote, reasonable effort to ensure that direct contact is made with the student's parent on the same day. So it's kind of same day notification light. So that this is one of the few places where I actually provided a citation to the private school regulations, because it's one of the few places where the private school regulation is actually a little stronger. In the private school regulations, same day notification, quote, shall be provided on the same after a restraint and exclusion incident. So that's a little bit stronger language, but reasonable effort is better than nothing. There's an exception to same day notification requirement for restraint exclusion incidents that occur after the school day. So if there's an after school event and 7 or 8 o'clock in the evening, a child is subject to restraint or seclusion, that notification may not happen until the next day, perhaps. In addition to notifying the parent, anytime there's a restraint or seclusion incident, an incident report must be written. And importantly, that incident report has to be provided to the parent within 7 days of the incident. The regulation states that the incident report, quote, shall contain information sufficient to inform the parent about the incident. And then it goes on to provide terrible regulatory language. It says, such information would typically include the following. You see things like would typically include, that means these provisions are not really enforceable, but they're useful guidance. And so what would it typically include? Essentially, what it is the who, what, when, where, why, and how. So who was restrained by whom, what occurred around the incident of the restraint, when did it happen, where did it happen, why, what was the behavior that resulted in the restraint or seclusion incident, and how, what method was used. And then in addition to those requirements, there's an annual reporting requirement. So every year, the superintendent of public instruction has to report the frequency of the use of restraint and seclusion in their schools. And importantly, that information must be made available to the public. So these provisions put together ensure that parents will be informed of the incidents of restraint and seclusion involving their children, and ensure that there is much more transparency about the use of these interventions going forward.
So next, we're going to talk a little bit about prevention. There's a specific section of the regulations that discusses required steps schools have to take for certain students in order to implement different interventions or preventative tools so that restraint and seclusion will not need to be used on a student. The first group of students who the regulations discuss are students who have an IEP or a 504 plan, and they have behaviors that are likely to result in restraint and seclusion. The team must consider these following things. So this may be a student who previously has had a history where they've been restrained or secluded in school, or a student who the teacher or school staff is noticing certain behaviors or escalations in behaviors or difficulty with school staff in working with that student that indicate that there may be a future incident that could result in restraint and seclusion if we don't start working on some strategies and things to address the behavior. Could also be a student who the parent has expressed some concerns, maybe in the home setting, and there's starting to be some behaviors in the school setting that again would indicate that there could be a likelihood that restraint or seclusion could be used in the future. And in those cases, the IEP team or the 504 team has to get together, talk about the needs of the student, talk about maybe the behaviors or the other factors that are of concern, and discuss these enumerated things. The first is a functional behavioral assessment. And we could talk about that for an hour on its own. So just to give you a brief definition for those of you who are not familiar with FBAs, a functional behavioral assessment basically takes a specific behavior that wants to be analyzed and looked into and assessed. And someone with a behavior analysis background will maybe do classroom observations or talk with the parent or the student or the teacher and try to digest what's happening before the behavior, the antecedent, and what's happening right after the behavior, the consequence, and try to determine what may be a trigger of that behavior or what a student may be getting out of a certain behavior that's encouraging that behavior to continue to occur. And then we'll also include some suggestions as to how that behavior can be worked on. So the team has to contemplate a need for an FBA. If a student has had an FBA before, maybe there needs to be an updated FBA if the environment in which the behavior is occurring has changed, if the triggers have possibly changed, if there's a new behavior, an additional FBA may need to be conducted. And the next thing the team will consider a need for is a new or revised behavior intervention plan, or BIP. And what that is a lot of times that's drawn from the data and conclusions in an FBA. And that is a plan for what do teachers need to do when working with this student? What do teachers need to maybe work on with this student in terms of behaviors or coping skills? What are certain things that the teacher, school staff, or the student themselves, especially as they're getting older and learning these coping skills, what's the plan for when behaviors start? How do we de-escalate those behaviors? How do we prevent the behaviors? That's basically what a behavior intervention plan outlines. And in the regulations, when considering whether or not there may be a need for a new or revision to an existing BIP, the team has to consider specifically not just the causes and purposes of the behavior, but also, again, de-escalation strategies, conflict prevention, and positive behavioral interventions. The regulations specifically outline that in these behavior intervention plans, we need to not just be thinking about how do we address a behavior when it occurs, but how do we de-escalate? How do we prevent? The next thing the team will look at and consider a need for is new or revised behavior goals. So that's, again, could be working on coping skills, replacement behaviors, or new evaluations or re-evaluations. So maybe, for example, if students get really frustrated, but they're getting really frustrated in class because they actually have some stuff going on visually, and they need a visual assessment to see if they need corrective lenses or other accommodations or assistive technology. And if they had those things, maybe they wouldn't be having some of these behaviors. So it's really taking a look at all the different tools in that special education toolkit to see what can be implemented to help address any behaviors or concerning circumstances when they're first noticed by the team before they get to a situation that may necessitate restraint or seclusion. So the next group here is students who have unfortunately been restrained or secluded in a school year. So if there's a student who's been restrained or secluded for a second school day within the same school year, and they have an IEP or 504, that team has to meet within 10 school days of that second day, and they have to discuss the incident, and they have to consider the need for those same items I just discussed. So this isn't only a, okay, once a year, we're gonna come to the table and talk about what's going on. If we are seeing that there is restraint or seclusion happening to a student with an IEP or a 504 plan, we have to then get back together, figure out what's going on, and reassess the situation to try to implement those strategies to prevent this from happening again. The final category of students in regards to prevention that schools have to implement are for students who don't have an IEP or a 504 plan. So this is triggered again when a student without an IEP or 504 plan has had a second school day within the same school year where they've been restrained or secluded. In this case, the team is going to look a little different because there isn't an outlined IEP or 504 team already in place. And those team members under the regulations are going to include the parent, the principal or their designee, a teacher of the student, the school personnel involved in that incident of restraint or seclusion, and other appropriate personnel as determined by the school division. And that could be a school psychologist, that could be a school counselor. And the team, again, has to come together, discuss that incident that occurred, and the need again for an FBA, a behavior intervention plan. In this case, because the student does not already have an IEP or 504 plan, whether or not there may be a need for referral of an evaluation to determine if a child needs a 504 plan or special education services. So there's some pretty specific language in the regulations regarding these preventions for students who may be at risk of restraint or seclusion, and trying to make sure we're implementing all the tools we can to make sure this doesn't occur.
All right, we're going to talk about the training requirements contained in the regulations. And there are really two groups of two separate issues here. So the first is training that has to be provided to all personnel. So this is, doesn't matter what class you teach in, doesn't matter what you do in the school. If you work there, you go through this training. And the 5 enumerated items here, the verbiage is taken right from the regulation. There's a lot of overlap between some of these topics. I would summarize these as essentially 2 things. The first is crisis intervention, and the second is or crisis prevention and intervention. And the second is the regulations on the use of restraint and exclusion themselves. And this is good stuff. That you'll notice something that's missing from here is how to use restraint and seclusion. I mentioned a moment ago that I used to work in a psychiatric facility. When I started there, one of the first trainings we received in orientation was called restraint training. And you would go to the training, focus on teaching train people. And then shortly after I started there, we started a restraint reduction initiative. And one of the first things we did was we changed our restraint training to crisis prevention training. And the last thing we covered was, if you absolutely have to, this is how you restrain someone, but here's how you don't. And that's what this is about. So the training that all teachers have to receive is training in how not to restrain someone, how to use positive behavior support, how to use conflict prevention, how to use de-escalation, crisis response, and then information about the regulations that prevent the use of restraint and seclusion to circumstances where they're necessary to prevent imminent harm. Only on our next slide, we get to the individuals who have to receive what they call more advanced training. And this is the training that you receive in actual restraint and seclusion techniques. And so only a select number of individuals have to receive that, including one administrator in every school building, and any school personnel assigned to work with a student who's determined by their IEP or 504 team to be at risk of restraint or seclusion. And so everybody has to receive basic training in intervention and restraint exclusion regs. A select few have to receive training in actually implementing restraint and seclusion, and these are the people that are most likely to be involved in it, so that we know that they at least know how to do so safely.
So we've talked a lot so far about what is considered restraint and seclusion under the regulations, when it's explicitly prohibited, the only circumstances in which it could be permissible, as well as training. But that still leaves a lot up to, practically speaking, day-to-day, how restraint and seclusion is to not be implemented or is implemented within a school division. And the regulations contemplate that they can't necessarily address every circumstance that may come up. And they do understand that school divisions are going to have to create their own policies and procedures regarding that particular division's use of restraint or seclusion or prohibition on restraint and seclusion. So they outline the requirements within a school division for creating those policies, and that's what we're going to go over now. So at a minimum, those school division policies and procedures have to meet the requirements of these new regulations. So everything we've discussed today, that is the bare minimum that a school's policies or procedures have to meet. And then in addition to that, there's more specific requirements that are outlined on the next few slides here. So first, there has to be a statement of intention that the school division will encourage the use of positive behavioral interventions and supports to reduce and prevent the need for physical restraint and seclusion. So this is another area where we see again in these new regulations that there is a focus on other interventions and less restrictive interventions than this use of restraint and seclusion. Examples of positive behavioral intervention and support strategies also have to be included in these policies. So it's not enough for a school to just say, we're going to try to utilize positive behavior interventions. Those policies need to explain some examples of strategies that could be used instead of seclusion or restraint. Next, schools are required in their policies and procedures to have a description of that initial and advanced training that John discussed. And though that has to address at a minimum the appropriate use of effective alternatives and the proper use of restraint and seclusion. So as John just discussed, there's some basic training requirements that are prescribed in the regulations, but then a school division's policies and procedures are supposed to become more specific regarding what the content and nature of that training is going to be. Next is a statement of the circumstances in which physical restraint and seclusion may be employed. Again, cannot be any less restrictive than what's set out in those regulations. And as I touched upon earlier, schools are currently in the process or have very recently implemented their new policy and procedures in accordance to these regulations. And some school divisions are taking steps in their policies and procedures to phase out or eliminate the use of seclusion and or restraint. They also have to have provisions in their policies and procedures addressing the notification of parents, including the manner of that notification. So is there going to be a phone call? Is there going to be email? Is there going to be a letter? Is there going to be all three? What order do we do those in? That needs to be addressed in the policies and procedures. Also, how a school division is going to document the use of physical restraint and seclusion. And that's really important to make sure you understand your school division's policies and procedures on that. If there is a concern regarding a particular incident that needs to be addressed later on, it's really important to know exactly what kind of information and documentation and recording of those incidents is going to be collected by the school. Next, the school policies and procedures have to talk about that continuous visual monitoring of the use of physical seclusion or restraint. There is a narrow exception here for emergency situations where that monitoring cannot be implemented because it's an imminent emergency. But they have to make sure they're addressing how are we making sure that this is being monitored, this is being watched. So in those cases where restraint or seclusion is being used, that we're ensuring that it's done so, at least from a physically safe standpoint. And securing of any room in which a student is placed in seclusion. Again, John mentioned and referenced the regulations and specifications for seclusion rooms. So those policies have to make sure that any area that's going to be used for seclusion is in compliance with all those regulations. And specific again to seclusion, they have to discuss the appropriate use and duration of seclusion based upon the age and development of the student. So school division's policies and practices should not have the same policy in place for seclusion of a 5-year-old versus an 18-year-old who's a senior, right? They need to be looking at both the age, but not only the age, the development of the student and taking that into account when developing these policies and procedures. Now, we're going to touch upon here school resource officers, which I think has been something that's a pretty widely talked about topic when it does come to specifically restraint, but restraint and seclusion. School resource officers are excluded from the definition of school personnel. So you'll notice a lot of places in the regulations regarding the use of restraint or seclusion places requirements upon school personnel. School resource officers are exempt from that. However, school divisions have to work with the local enforcement agency if they're contracting with a local law enforcement agency to use school resource officers. They have to create what's called a Memorandum of Understanding, which is basically policies and procedures that are agreed upon between those two entities as to how SROs are going to be using restraint and seclusion, if at all. This is compared to school safety officers. School safety officers are directly employed by the school, and they are then considered school personnel, And any requirement under these regulations that refer to school personnel would also include school safety officers. We've included in the materials that we'll be sending you is a sample model memorandum of understanding that was developed between the Department of Education and the Department of Criminal Justice Services. Schools are not required to use this exact MOU. It's just an example, and schools do have that discretion to work with their local law enforcement agency to draft their MOU. Now, the last couple of things here regarding policies and procedures. The first is that school divisions have to post on their website the updated policies and procedures regarding restraint and seclusion. So those have to be available online. They also, in addition to that, have to make available printed copies for those who don't have internet access. So that should be something that as schools either have developed in the last couple of months or in the process of going through school boards and developing these policies and procedures, they need to be posting them available, making them available online. And finally, the regulations also say regarding this process of policy and procedure development that schools have to consider implementing strategies that involve parents and collaborate with parents in the development process. So the regulations do say that schools should be considering ways in which they can bring parental input and collaboration to the table when making these policies.
All right. Now, on to the fun stuff. Enforcement. So what provisions do the regulations have that speak to the enforcement of the regulatory provisions themselves? And the answer is they don't really. And this is one of the big open questions with respect to the restraint exclusion regulations going forward. It's just how these things are going to play out. We do know that in at least some circumstances, the use of restraint and seclusion can result in the denial of free and appropriate public education, and they can constitute unlawful discrimination in violation of the ADA or Section 504 of the Rehabilitation Act. And so in those circumstances, the avenues available to redress those issues, grievances, are available to us. On our next slide, we'll provide a link to, this is from years ago, the Office of Civil Rights and the U.S. Department of Education issued a Dear Colleague letter outlining exactly how the use of restraint and seclusion can constitute denial of FAPE and can constitute discrimination. And so, and the link there would bring you to that Dear Colleague letter. And that's a really important resource for anyone looking at how to make that case. And so that's one avenue to enforcement of these is essentially to wrap the issue into a special education issue or a discrimination issue. On that, it's a work in progress. There's lots of opportunity though, on an individual level to engage in advocacy related to this. You think back to the prevention components that Carrie eloquently laid out in Section 80 of the regulations, which require IEP and 504 teams to consider steps to prevent the occurrence of restraint or seclusion when you've got a child whose behavior puts them at risk of those interventions. And remember the mandatory meetings after multiple incidents of restraint and seclusion for both students with disabilities and students without identified disabilities. We often talk about students with disabilities versus students without disabilities. Many students who are not on IEP or 504 plans are actually students with disabilities if you define a student with disability as a student who meets the ADA definition of a disability. And then we're going to go back to something else I told you we were going to come back to earlier, which is the prohibition on the use of restraint and seclusion when medically or psychologically contraindicated. This is an area where, if you know that a child has a contraindication to the use of restraint and seclusion, This is an area for significant opportunity for individual advocacy in ensuring that that contraindication is documented, either by the IEP team, if they're so willing, or by an independent medical or mental health professional. There are some questions about this provision and how it's going to be implemented and how controversies will be resolved. The regulations are not clear on what happens if we present, for instance, a letter identifying types of restraint or exclusion or restraint exclusion in general as contraindicated, and the school division pushes back, and we expect to see that occur. But this is an important provision, provides important protections for people with significant reason for not being subjected to dangerous interventions.
So a couple of kind of advocacy tips here. If you're working with your own child or advocating on behalf of another student and looking to do some individual advocacy regarding restraint and seclusion. The first is documentation. So make sure you're keeping track contemporaneously. So when it happens, if you can, of any concerning, again, going back to, what makes necessary that coming to the table, behaviors that are a concern, actual incidents of seclusion or restraint, making sure you're keeping track of that, making sure you're requesting copies of any incident reports or other documentation regarding any instances of seclusion and restraint, or again, any other incidents at school that may start to indicate, that escalating of behavior that could put a child at risk of seclusion or restraint, making sure you're getting that documentation, reviewing it. Reference the regulations. So if there is a concern regarding seclusion and restraint of a student and it doesn't seem to be in line with what the regulations require, or maybe the school is not taking a step that they're required to regarding that prevention, having that IEP meeting prior to restraint or seclusion occurring when there's behaviors present in the school setting, go back through these materials we're providing you today. You can pull up the regulations themselves and have all the direct quotes of those regulations online. Make reference to those regulations if you believe the school is not following the requirements under these regulations. The next thing here is something we really tell our clients when we work with them on a wide variety of topics, is make sure coming to the table when you first have that first communication with the school, you have a clear understanding of not only what you're concerned with, but what you would like to see happen. Make sure you have specific things that you're looking to have happen. Is that a change to the IEP goals or additional IEP goals? Is that additional supports? Are there certain staff who need additional training? Does your child maybe need to be moved to another classroom? Make sure you have in mind not only what you're concerned with, but possible solutions. You don't always have to know the solution, but if you do have something in mind, make sure that's something you're talking to the school about. And if not, coming to the school and addressing those concerns and asking them what they think could be done, what strategies could be put in place to prevent anything regarding restraint or seclusion. And then finally, get it in writing. So if there's anything agreed to between you and the school, make sure that's in writing. If it's appropriate to be added to the individual education plan or 504 plan or behavior intervention plan, make sure that it's formally included in those documents when it's appropriate. Also make sure that you're looking at the content of what that writing is. So you want to make sure that content is detailed and specific enough to really make sure everyone is on the same page, and that somebody reading that document 6 months from now has a clear understanding of what was meant when everyone came to the table, so that you know that it's being implemented in the way everyone discussed and agreed to, and isn't kind of left open for interpretation or misunderstanding later on. John, do you want to talk a little bit about the systemic advocacy options?
Absolutely. So, yeah, and as Carrie discussed previously, school boards are required in school divisions that choose to use restraint exclusion to adopt policies and procedures. And so there's significant opportunity for advocacy on a systemic level locally is not only are school divisions required to adopt policies and procedures, but they're required to review them annually. And so most school divisions have already adopted new policies and procedures consequent to these regulations at this point. Some are still in the process of approving those. But even those that have already adopted them, the annual review requirement provides opportunity for public comment before the school boards, encouraging them to take actions to ensure that their policies and procedures are consistent with regulations, and individuals can advocate for those policies and procedures to go beyond regulations. The regulations are the floor. There are school divisions that have gone beyond the regulations already. Fairfax County notably has put in place a policy that will phase out the use of seclusion in their district. That's huge. We're not seeing a lot of people rushing to that for that option, but there's significant opportunity for advocacy on this on the ground at the local level to encourage school boards to adopt policies and procedures that are more stringent than what the regulations are. Those policies and procedures, if you're looking for them, they have to be publicly available. Most school boards in Virginia, if you go to the school board's website, you can find a link to their policies. And most, but not all, school boards use the same policy breakout. And the sections of the policy are listed alphabetically. Section J is a section that has all the student stuff, the codes of conduct and stuff, and section JM addresses restraint and seclusion. So for most school boards, that's where you're going to find the restraint and seclusion policy. And many have JM, I think it's JM-R or something like that. So they'll have a broad policy under JM and then a subsequent sort of more detailed, they either call it procedures or some call it a regulation. So review those in your area, ensure that they're consistent with the regulations, and by all means, take the opportunity during school board meetings to advocate for even stricter procedures on the use of these practices in your localities. And of course, it wouldn't be a presentation without a shameless plug at the end. So please visit our website, check out our resources on special education and restraint and seclusion. We recently developed a complaint portal specifically to receive complaints related to restraint and seclusion. So if you have a complaint about the implementation of these regulations, about the use of restraint and seclusion, the link to that complaint portal is located on the slide. You're also welcome to call us. Our number is on the slide for any of your special education needs, but we're particularly interested in the implementation of restraint and seclusion regulations. And now I suppose it's time to entertain questions that may have come in.